It's in Georgia. It's almost impossible to start anything at 9 a.m. Usually, life starts here at 10 a.m. So I see that our participants have adopted Georgian the habits, but I'm really happy and glad for those of you who are able to get up early in the morning and start our meeting at 8:30. That was a real kind of the challenge, but great to have all of you with us. So it's a real pleasure to chair this session, which will explore the question of discrimination in criminal justice. The right to fair trial is a foundation of criminal justice system. It's aspiration that really should drive any improvements that take in the system. And the right to legal aid is a safeguard to ensure that everyone who is charged with a crime will be treated equally, despite their financial or social circumstances. There are many crises which afflict criminal justice systems, and those include institutionalized discrimination against racial and ethnic minorities and other marginalized populations. So at this session, we are going to look at two aspects of it: race and ethnicity, both in historical context as well as the disparate impacts that seemingly or potentially neutral or fair policies may result in disproportionate representation of ethnic and racial groups in criminal justice system, and to look at another might have been one of the longest standing form of discrimination against women, and then how they manifest in today's policies and practices across different countries. So we will be looking at, there are many ways, or there's the need for very complex approaches to deal with discrimination in criminal justice. Obviously, the legal aid is one of very important tools in addressing that, fighting for individuals, fighting for systemic problems, trying to change policies and practices. So we have several examples which we are going to discuss today at this panel to really explore how different groups, really advocates in the field, have been challenging those the problems, and what their experiences are in this regard. Are they making real progress? Are things improving? And then where there are problems, how to understand the real the reasons, or what drives discrimination, what are the inherent biases that are, the criminal justice systems obviously run by, human beings, like all of us, and how those implicit biases and other societal, historical, and social norms that have evolved over time historically are, really creating real challenges in administration of justice, and eventually, and very, very significantly, really undermining legitimacy as a result of those disparate impacts or discriminatory practices that criminal justice systems experience in many countries in the world. I'm really honored to chair the panel with such distinguished speakers that we have today with us. I will introduce them as they will speak. Our first presenter is Castro, who is the head of the Public Defender Office in the state of Rio de Janeiro in Brazil. It is a public defender system with over 800 lawyers really working together to advance right to legal aid and right to a fair trial in Rio de Janeiro. So André will talk about the work of the Defensoria in Rio, in favelas, and how they are trying to really promote the notion of equality and fairness for those particularly who are most poor and vulnerable, and where the race plays a significant factor in determination of people's fate when they come in conflict with the criminal justice system. So Andrea?
Thank you, Zaza. It's a great pleasure to be here in your country. Good morning, everybody. Today I will speak about the work of the Public Defender Office of the State of Rio de Janeiro in partnership with other public institutions and civil society organizations to provide legal assistance to the vulnerable population within the favelas of Rio de Janeiro. Before that, I'd like to quickly introduce the Public Defender Office and the Brazilian recent context which gave rise to this project called Favelas for Rights Circuit. How can I change the slide here? Okay, this way. To introduce the Public Defender Office in Brazil, I'd like to show our federal constitution. It establishes that Public Defender Office is an expression and instrument of the democratic regime and fundamentally responsible for legal assistance, promotion of human rights, promotion of human rights, and the holistic and free defense at all courts of individual and collective rights of needy. Independence and administrative autonomy are assured, as well as the proposal of our budget. Thank you. Brazil has a population of 209 million inhabitants, most of them being black and brown. It has the third largest prison population in the world, with more than 700,000 prisoners, 2/3 of whom are black or brown. The city of Rio de Janeiro, in turn, has 6.5 million inhabitants, and 2 million people live in favelas. More than 70% of the favela dwellers are black or brown people. Brazil has a high rate of homicide, even much higher than many regions in the world that have experienced war or civil war. Black victims of homicide are more than double than white victims. In a decade, the black people homicide rate grew by 23%, while the rate of non-black people decreased nearly 7%. Most homicide victims, the next please. As you can see, most homicide victims are young people. In this age group, black people die 2.5 times more than white people. The next one. Among all states of Brazil, Rio de Janeiro is the highest percentage of deaths caused by state agents. From January until now, almost 1,200 people in Brazil were killed by police. We can see in the slide there is a visible rise in police lethality during this current year, which may be associated to the increase of the police operations in favelas. During last Carnival holiday, scenes of disturb and street violence were broadcast repeatedly on TV. Then, the President of Brazil signed an extraordinary act establishing that the public security of Rio would be in charge of the army. At that time, federal government officials announced the increase of police operations in favelas, including authorization for invasion of houses and mass arrests. Because of that, the Public Defender Office in Rio stated that the fight against crimes doesn't authorize violation of individual civil rights by the state, penalizing only poor and black population living in the city's poor neighborhoods. Since then, the Public Defender Office has adopted a set of measures for the legal defense of dead people, such as individual lawsuits, compensation for victims and their families in cases of death or injury, class action to prevent damages and reduce the use of police force, and so on and so forth. One example was the court decision establishing measures to prevent the use of violence in areas as school, kindergartens, and health posts. Another action was the project Favelas for Rights Circuit, an initiative of the representation of the civil society in the Public Defender Office. In partnership with public and civil organizations, this monitoring program of police operations in favela has been launched. Since April this year, the teams are visiting the favelas and interviewing residents. 27 places were visited until now, and more than 400 reports were documented and classified. The main goals of the project are: give visibility to the violations suffered by residents, gather all reports in a single document, identify patterns of violation, and use it as basis for public policies, and also the adoption of judicial measures to stop violations. The project has many partners, and the numbers is still growing. This is the members. The Human Rights Commission of the State Legislative, the Federal Public Defenders, the Association of Favelas of Rio de Janeiro, and other organizations of civil society join us since the beginning. And currently, even the State Prosecutor's Office of Rio de Janeiro is participating. The first group of violations concerns home invasions, which happens without court order. As you can see in the slide, the invasions are so common that one resident has even set a warning on the door of his house saying, you can see the warning, it says, "Police officers, please do not break the doors. Pick up the key at number 3 in front of the store or look for the name of the person." Next, please. Also frequent are the police raids and stop and search. Approach protocols are frequently not observed. Verbal and physical assaults are reported. Children's backpacks are opened for search, and also orders to unlock cell phones to check the private messages. The violence of the drug dealers and of the state forces in the favelas is a sad history of killings and executions. In recent years, the use of police force has been intensified, including the use of helicopters and, since the intervention, the federal intervention, the use of war tanks, as you can see in the picture. The police that kills is also the police that dies. During this year, more than 70 cops were killed in Rio de Janeiro. The Public Defender Office filed an ongoing class action in order to guarantee some transparency in the execution of the operations, hazard prevention, and accountability. Another lawsuit was also filed against the state government to stop police helicopters shooting. A few weeks later, the Secretary of Security issued a protocol blocking this practice. The impact of the struggle against drug dealers on the daily life of the residents is enormous. Schools and health clinics cannot open. Many residents are unable to leave their houses because of the shootings. Shots, noises, war tanks, and helicopters bring daily trauma to children and adults. This quotation you can almost see in the slide is very symbolic. She is a councilwoman. She was killed this year, in the beginning of the year. Her name is Marielle Franco. And for all the community, the feeling is that if she, that was a councilwoman, was killed, who will be the next? These reports and all the others were submitted to the State Public Security Department, and many judicial matters, such as class actions, have been filed. The Public Defender Office has been supporting community leaders with the preparation of a booklet of citizen security and courses about legal guarantees for residents. We also act in the Supreme Court as amicus curiae in order to be declared unconstitutional a bill passed in 2017 transferring the military court to the military court the jurisdiction to prosecute crimes committed by militaries against civilians or by civilians against military. In spite of all the important efforts to protect the lives and dignity of these families, the number of casualties continues to grow. The policy of war on drugs costs too much for poor people, and it should be changed. Thank you.
Thank you, Andrea. Just devastating effects of really criminalizing whole populations, and essentially in Brazil, it has become the policy, not only the disparate impact of a practice which is on its face neutral. We will now go to the U.S., where this is the very long-standing battle for justice and equality. Probably no one could speak better to this topic than our speaker today, Rick Jones, who heads the Harlem Neighborhood Defense, which has developed a holistic approach to defense to, really, protect, defend, and advance right to equal treatment for all Americans. Rick,
thank you,
the
Zaza.
floor is yours.
Thank you, and good morning. I have a PowerPoint, but I'm not going to use it. And I know that when my staff watches this tape, they'll be very disappointed that I didn't, because a lot of effort went into it, and it's very good. But I want to keep this short, and I want to keep this brief. And also, I will tell you that there is an article that we published out front at the table that goes into much more detail about the things that I'm going to talk to you about now. I don't need to make the case or to give you chapter and verse, I don't think, of the fact that the justice system and the legal system in the United States is racist, and that it is sort of morally bankrupt and horribly broken. I think that's probably universally known, particularly in this room, in this audience. The overwhelming majority of people who find themselves brought into our legal system in the United States are black or brown, and also largely poor. And I don't think that I know you all know the statistics. You all know the issues we struggle with respect to pretrial detention and over-criminalization and mass incarceration, and sort of the racist layer that runs through every element of our justice system. So what I thought I would do instead, and more profitably, I believe, because many of you I know are legal aid lawyers, are public defenders, and some of you work in circumstances and conditions that are incredibly difficult, and it sort of is always an uphill battle. And I said this to a group yesterday morning, and I pretty much said it everywhere I've been when I meet with public defenders around the world, around the United States and around the world, that you are really heroes, and the work that you do is righteous and admirable, and I think that you fight the good fight every day, and you are heroes. So what I really would like to do with the very limited time that I have is talk to you a little bit about the way that we deal with the sort of oppressive racism that we find in the United States, and particularly in New York, and even more specifically in New York City and in Harlem. We have in my office a number of sort of core values that guide our work every day, and that give us the sort of structure to really fight the racism that we see in our courts every day. And while there are ways that you can fight the structural racism and the systemic racism and with litigation and impact litigation and mass litigation, I really think that for folks who are in the trenches every day, there are a few core principles, and I'm not going to go through all of them. You can read them in the article outside, but I'm going to go through just 2 or 3 of them that I think are really important and that you should really try to make a part of what you do every day in your practices, what you do every day in your courtrooms and your courthouses, and what you do every day with your clients. And those core principles are these. The first is to be client-centered. And what that means is that it's clients first, clients last, clients always. And the 2 things that you are really trying to do in building a relationship with your clients are these. The first is to build a trust relationship, to build a foundation of trust with your client, because if you don't have that, anything else that you do in the scope of your representation is not going to be as meaningful and not going to be as valuable and ultimately not as successful if you've not built that trust relationship in the beginning with your client so that your client has faith and confidence and trust in you and vice versa. And the other thing that's important in the client relationship, and this is really key to all that we do and all that you do as legal aid lawyers and as public defenders and as advocates in front of decision makers, whether it be a jury or a judge or even your adversary, is that you have to work to humanize your clients. You have to get to know your clients, you have to build the trust relationship, and you have to humanize your clients, because too often, particularly with judges and other decision makers, they see a parade of black and brown faces going through the system every day, and your client to them is just another allegation or just another charge or just another poor person or just another black or brown face. And until you can stop that sort of mill and humanize your client and help the court and help the jury and help whoever else understand that your client is a human being, that there are people who love your client, there are people who care about your client, that your client matters. When you can humanize your client, then you begin to change the landscape of the litigation. You begin to change the landscape of the case, and you also begin to counteract the crushing sort of forces of racism and discrimination that exist in the system. Because what happens, and this is something I really want you to take away, is this: reason follows emotion. And if you can get to the heart of the matter, if you can humanize and get to the heart of who your client is as a person, and get the decision maker to understand and feel that your client is human and find that emotional center, people will comport their reasoning to follow where their hearts are. So reason follows emotion, and if you can humanize your client, and if you can get to the heart of the matter with respect to the issues in your case, and show the decision maker that your client is a human being, someone who is deserving of respect, and then what really happens is that you begin to change the narrative, you begin to change the landscape, you begin to change the outcomes, and you begin to beat back the forces of disparity and oppression and marginalization that exist in that courtroom, and you begin to change the paradigm for your client if you can really help them see the humanity of your client. So clients first, clients always. Clients first, clients last, and clients always. And I would also say that your client is either Mr. Jones, or it's Rick, or it's your client. I would get away from using the word defendant. I've heard it a number of times. We don't use it in my office. Clients are not defendants. Defendant really casts a bad light for your client if you're using it in front of a decision maker. So try to humanize your client in every way that you can. The second sort of core principle for us, and I think that it's something that can be applicable to all of you and all the places that I've been, is that you have to really get involved in the community. And you have to really become a community-based organization. You want the community to think highly of the legal aid society. You want the community to think highly of the public defender's office. You need to be active and engaged with your community. And it reaps a number of benefits for you. First is that it allows you to do outreach and education in the community. It allows you to go into the community and to say to people, we're here, we exist, this is who we are, these are the services that we provide, come and use us, trust us, and let's work together to empower and support the community. So outreach is important. The other thing that's important with respect to the community is education and empowerment. Help the community understand their rights. Help the community understand that the Constitution applies to them. In Harlem, we have generational oppression. Granddad was oppressed by the police, Dad was oppressed by the police, and now Junior is oppressed by the police. And when we can begin to break that cycle and help people understand that not only are we there to help them, but that they have rights and the Constitution applies to them, it changes the dynamic in the community, and the community becomes your support. And when you go to churches or community groups or housing groups or school or education groups, and they begin to understand and trust and believe in your public defender office, they become a support for you, and there's power in numbers. And so when you have a case and your client is sitting in that courtroom and the judge looks up and sees not only your client sitting there, but now he sees the church, your client's church members sitting there, or the coach, or the educational folks, or the community folks, and the courtroom is full of people supporting your client, again, you've begun to change the dynamic. You've begun to change the paradigm. You've begun to beat back the racist or the disparate thoughts and ideas that may be coming from the decision maker. And now the decision maker is taking a different look and a second look and a better look at who your client is and what the outcome of this ought to be and how we ought to handle it. They're sitting up straighter and they're behaving in the courtroom, and it's not the same old thing when you've got a courtroom packed full of community folks. So the second thing I would say is really get involved in the community, know your community. The community is wherever your clients are. So really take advantage of the power that exists in the community and the support that you can get for the work that you're doing and for your clients in the community. The next thing that I would say is what we call early entry. And that means getting involved in cases as early in the process as you can. In our office, we frequently get involved in the case before there's even been an arrest. And when you can get involved in a case early, it completely changes the dynamic. It completely changes the complexion of the case. It begins to level the playing field. And so what happens traditionally is that someone is arrested. They're taken to the police precinct. They're interrogated. Frequently, they'll make an admission or they'll sign a confession. There'll be some sort of identification procedure. They'll be identified and picked out as the person who did it. Maybe the prosecutor will be called. The prosecutor will do an additional interrogation. Maybe that'll be videotaped. They'll sign a confession. And then that person will be taken to the courthouse. And it's not until that person is taken to the courthouse that they finally meet their lawyer. And by that time, you're not really talking about guilt or innocence anymore. What you're really talking about is, what's the best deal I can get for you, right? When you get involved in cases early, and you have the ability to impact what happens early, you have the ability to stop interrogations, you have the ability to stop confessions and admission, you have the ability to make sure that identification procedures are done correctly and constitutionally. When you have the ability to get involved early and get out and investigate the case on your own so that you know as much as anybody else in the courtroom, when you have the ability to have your social workers and your advocates filling that courtroom with people who love and respect and care about your client, so the judge sees that it's not just your client, but there's a community there. When you have the ability to get involved in the case early, it completely changes the dynamic of the case. And now what you're talking about really is guilt or innocence. Now what you're talking about really is, can I get a fair shake here? Now what you're talking about is, I really can overcome some of the oppression and the marginalization and the racism that exists in the system, and now really give my client a fair shot at justice, right? So I would encourage you in your communities, in your towns, in your jurisdictions, to really fight to get involved in cases as early as you can, because it changes the landscape of the case. And then the last thing I would say is I know Zaza wants me to hurry up. The last thing I would say is aftercare, what we call aftercare. And what that means is that many times after a client's matter is resolved, there's no more legal issues, a client will still have a relationship with our office because we will be working to address and deal and understand whatever sort of brought them into the system in the first place, whether it's drugs and alcohol, whether it's mental health issues, whether it's job readiness skills or education, whatever sort of the needs were that brought the client into our office and into the system in the first place, we began to help them address those issues so that they can go back into the community stronger and better and whole and more able to overcome and resist and fight and defeat the racism and the oppression and the marginalization and the disparity that is inevitably existing in our system. But when people feel empowered, when they know they have support, when they have a trust relationship, and when there is someone there who is helping them to really deal with the issues that brought them into the system, and you heard it yesterday from Ms. Kane Muldrow. If someone had been there, not at the 83rd time she got arrested, but at the first time she got arrested, her life would be dramatically different than it is now. And I think that individuals and as advocates, if we just employ some of these principles, you'll be surprised at how effective you can be at changing the lives of your clients and really helping them overcome some of the incredible odds and some of the incredible challenges and some of the incredible disparities that they have to face. And it will really help you in the incredible heroic work that you're doing, and it will also really be impactful in terms of changing the lives of your clients. So I really encourage you to think about the fact that there is power in public defense and that you are the power of public defense. Thanks.
No, thank you, Rick. I was very happy you talked about empowerment and legal empowerment. Essentially, the lawyers are really intermediaries to really bring power of law and put power of law in people's and individuals' and communities' hands. And hopefully we have some time, for questions and answers, and it would be great to look at, about the experiences in Brazil and in the U.S. of proving discrimination in criminal justice. How do you make the case, document the case, and what success you have to make those arguments in the court. This is the area where we are making the baby steps in Europe. I'm saying we because my organization recently joined efforts with several other groups to make the first attempt to understand what are the disparate impacts on ethnicity and race in criminal justice systems in Europe. Such data does not exist because most countries in Europe make it illegal to collect race data for historic and other reasons, and there are some good reasons for that. But at the same time, that enables to really understand, why is it so that when you go to the detention centers and jails in many countries in Europe, you see just on its face that people with, the black or brown or other kind of origin distinguishing reasons, they are overrepresented in those institutions. So my colleague, Irmina Pacho from the Open Society Justice Initiative is going to present the findings of the first study on this matter. That is a comparative study across 12 actually EU member states, and then Krasimir Kanev, who is the chairman of the Bulgarian Helsinki Committee, is going to really speak specifically on Bulgaria. So Bulgaria was part of that comparative study, but Bulgaria also has had a long-standing experience of looking at this matter for the Roma population and others in criminal justice system in Bulgaria, to really present on what they have learned and what they are, really discovering in this area. So Irmina, why don't you start, and then Krasimir will continue.
Thank you, Zaza. Good morning, everyone. It's It's a great pleasure to be here and to speak about our work on disparate impact in criminal justice in Europe and to bring the research perspective to our discussions. So, as Zaza mentioned, the Open Society Justice Initiative, together with Justicia Network, has been cooperating over the past years on a number of research projects. We wanted to analyze how criminal procedural rights, arrest rights that are protected by the European Union law are implemented in practice across the EU member states. And at some point it became striking to us that although we've been receiving information about problems at the intersection of discrimination and criminal justice, there's actually little or no research evidence or other information in Europe on how suspects and accused accused persons belonging to ethnic, racial, or national minorities are treated within the criminal proceedings. There is also little or no knowledge and awareness of how members of these minorities experience these criminal proceedings. So to respond to this gap, Open Society Justice Initiative, together with 12 members of Justicia Network, we wanted to seek answers to questions that we have about the adverse effects of policies and practices of authorities that are based disproportionately on race, ethnicity, and nationality. Therefore, in 2017, to start these explorations, to make the baby steps, and to initiate documenting, we undertook research effort in Europe. So we started with a small-scale scoping study just to receive an overview of existing practices. The methodology was based primarily on the desk research, which was supplemented with interviews with key stakeholders. And it soon became quite obvious for us, as Zaza mentioned, that the main challenge we encountered was the lack of desegregated, anonymized ethnic racial data that would make it really difficult to monitor practices and outcomes of criminal justice institutions. But despite these difficulties, relying on more empirical evidence, the research led to some interesting findings. So first of all, the research showed and confirmed that in all 12 countries, the ethnic and racial minorities, as well as non-nationals, are significantly overrepresented at different stages of criminal proceedings. So, for example, in Estonia, there is a disproportionate representation of foreigners in pretrial detention. In Greece, disparities in sentencing affected foreigners who were given heavier sentences. In Hungary, Roma were more than 3 times likely to be stopped and searched and to be ordered and sentenced to pretrial detention. In Bulgaria, for example, 50% of prison population were Roma in 2015, and I'm sure Krasimir will talk about this more. So such disproportionalities might result from different factors, but this scoping study confirmed the existence of 2 of them. So first, the study pointed to the existence of institutional bias that leads to discrimination and these disparities. According to the research, stereotypes that are deeply rooted in the society are reflected in the practice of police officers, prosecutors, judges, but even sometimes in the practice of legal aid practitioners. And these biases, according to the research, leads to creating patterns of, for example, less favorable judicial resolutions, or overrepresentations of non-nationals in crime rate statistics or pretrial detention statistics. The second factor that was identified by the scoping study was that ethnic and racial minorities, as well as non-nationals in Europe, have unequal access to criminal procedural rights. And what was very visible and commonly underlined by in countries participating in this research was that these groups, these people from minority groups, they do not have effective access to translation and interpretation services, which then in consequence affected their right to be informed about their rights, about reasons of arrest, or about criminal offense that they are suspected of. Also, what was mentioned is that these minorities they don't have effective access to a lawyer, especially at the early stages of criminal process, which was also strongly linked to lack of legal aid schemes in many countries, or lack of clear proceedings of appointing legal aid lawyers. So these were the main conclusions of the scoping study, which was the first attempt on such a big scale in Europe to document practices of disparate practices in criminal justice systems. Of course, the scoping study was very limited, so it did not allow us to obtain answers to all the questions we had, but it kind of built an overview of current practices and identified main areas of concerns. So therefore, we believe that it's necessary to continue these efforts and to continue research in this field in Europe, because only when we gain more knowledge and information of current practices, and then that will enable boosting public discussion and hopefully obtaining changes in policies, laws, and practices in Europe, both at the national levels and at the level of European Union. The report will be soon available. The comparative report of the research will be soon available at the Justicia Network, and I strongly encourage you to read it. Thank you very much for your attention.
Thank you, Irmina, and I think it's not a finding here, but really the realization that inaccessible and poor quality legal aid services, which unfortunately is the reality in many countries in Europe, are disproportionately affecting those who are poor and vulnerable in various different ways. So the impact of those rights are much greater on those who need them most. Casimir?
Thank you, Zaza, and good morning, everybody. My task today is going to be to present a specific case of ethnic discrimination in the criminal justice system, the Bulgarian case. We were part of this scoping study, but we also had a long experience in studying ethnic discrimination in the criminal justice system from those surveys and research that I will present to you. You will see that we have been engaged with this since many years. So, every research, every approach to discrimination in whatever system has to start with the ethnic composition of the country, and I would like to say a couple of words about the ethnic composition of Bulgaria. We have to know what ethnic groups exist in order to find out how they are represented in the criminal justice system. Bulgaria is a country of around 7 million now. According to the census that we have conducted in 2011, Turks constituted some 8.8% of the population. Roma were around 5%. Other minority groups were around 0.8%, and 9% were undefined. Undefined means that some persons just refuse to indicate their ethnic belonging, their ethnic identity in the census. But most of these people belong to ethnic minorities, and therefore we believe, and researchers in Bulgaria believe, that this census figures do not adequately reflect the ethnic composition. And therefore, there were other ways to find out the real ethnic composition. And according to many estimates, we have two large ethnic groups, Turks, constituting between 8 and 9% of the population, Roma, or Gypsies as they're called somewhere, also around 8-9% of the population, and the others were the Pomaks, or the Bulgarian-speaking Muslims, Macedonians, Jews, Armenians, Greeks, Arabs of the Bulgarian, or these are Bulgarian citizens, Chinese who are also Bulgarian citizens. We have also migrants, but not many, around 1-2% of the population, which includes also EU residents in Bulgaria. Muslims, this is the largest religious minority, 13% of the population. This is the highest share of Muslim population in the EU member states, among the EU member states. Not the highest number, but the highest share as a percentage of the population. So this is the ethnic composition. What do we have now in the criminal justice system? We have several set of data which I would like to present. One is the ethnic minorities as identified perpetrators. Our Ministry of Interior collects data, used to collect data rather, until 2017 on the ethnic belonging of the perpetrators. They called it identified perpetrators. And we wanted to find out what does this mean, identified perpetrators. We discussed this with the Ministry of Interior, and they told us that this basically means that these are perpetrators who are formally charged for having committed a criminal offense. And here's what we have. Into the most recent year where we have such data is 2016. Overall, 16.7% of identified perpetrators of crimes belong to ethnic minorities. More or less the same share of the ethnic minorities as we have in society, as you can see. But look at the distribution. What crimes we are talking about? They were actually underrepresented in murders, 11.5%, or 0.2%. Also underrepresented in bodily harms, 15.4%, but overrepresented in theft crimes, 24%. And it is more or less the same shares over the years. Until 2012, as you can see, the Ministry of Interior used to collect also data by different ethnicity. In 2016, we have ethnic minorities in general, 16.7% of ethnic minorities, but they did not distribute this by different ethnic minorities. They used to do this by 2012. And you can see there the respective shares of ethnic minorities as perpetrators of crimes. In other words, as persons charged with having committed a criminal offense. Very importantly, if we look from 2011 to 2016, you would see a gradual decrease of the share of ethnic minorities as identified perpetrators. Look, in 2011, Roma were almost 20% of the perpetrators, and Turks were 2.8%. Altogether, 22, 23% of the perpetrators. Now, they are altogether 16.7%. So this is the statistics, the official statistics of the Ministry of Interior on identified perpetrators of crimes. Now we come to the composition of the prison population. This we found through a number of surveys that we did. We have been doing surveys among our organization as a permission to monitor prisons and to do research in the prisons, and we have been doing this since 1994, for many years. Our most recent surveys were two, from 2015 and from 2017. And here's what we have. These were large surveys of newly arrived prisoners. In 2015, we have interviewed 1,691 prisoners, newly arrived prisoners. And in 2017 survey, we have interviewed 1,357 prisoners. A very representative survey. We were basically aiming at interviewing every newly arrived prisoner over the past year and a half or past 2 years. In both surveys, we have, 50% were Roma of the prisoners in the 2015 survey, and only 8.8% of Roma were allocated in open type prisons. Then in 2017, we had almost the same share of prisoners. 51% were Roma, and more or less the same distribution by the type of prison. At the bottom, I have also some figures about women prisoners who were Roma, 42%, and juvenile prisoners who were Roma. Look at this figure. It is striking, no? 67% of all juvenile male prisoners were Roma. So we have 16.7% of identified perpetrators from all ethnic minorities, but in the prisons, more than 50% of the population is Roma. So how do we reach? What are the factors that brought this result? There may be many factors. Recidivism, by law, in Bulgaria, if you are a repeated offender, you get a sentencing enhancement. It may be also the type of crime, but we saw that the type of crime, they are basically charged of crimes that are not so serious, theft crimes, and other factors. And we have tried to explore some of these factors. Here's what we found. First, we had some statistics on the use of force by police. The use of force is one of the basic tools of our police to extract evidence from criminal defendants. Okay, thank you. In 2015, the CPT, the European Committee for the Prevention of Torture, issued a public statement against Bulgaria, in which it stated that this is a very frequent practice. In our survey, 1/3 of the prisoners in those surveys complained that they have been ill-treated by the police, either during arrest or inside police custody. Look at the overrepresentation of Roma as victims of police abuse in both surveys. 10% more Roma in the 2015 survey said that they were physically abused. And 13.8% of Roma said that they were physically abused in the 2017 survey. Access to a lawyer. We have done another survey in 2018 in 4 prisons only for repeated offenders, where most of the prisoners, more than 90% of the prisoners were repeated offenders, in order to be able to control for this factor, the recidivism factor, which is very important. Again, we found in those 4 prisons that 49% of the prisoners were Roma. And look at the figures. How, whereas in general, 17% of the respondents said that they did not have a lawyer at all. And 58% said that they did not have a lawyer from the beginning. In the case of Roma, 20% said that they did not have a lawyer at all, and 67% said they did not have a lawyer from the very beginning. So the access to legal assistance, in other words, for the Roma population was poorer in all those cases. And finally, and very importantly, I would like to, this is going to be my last slide, want to point at one judgment of the European Court of Human Rights, a very important judgment which I strongly recommend that you read. This is the judgment of Paraskeva Todorova v. Bulgaria from 2009. This is the only judgment in the case law of the European Court of Human Rights in which the court found a violation of Article 14, prohibition of discrimination, in relation to Article 6, right to a fair trial. Why was this? Because the court refused to suspend her sentence. She was a criminal defendant, Roma, with the following reasons. There's a feeling of impunity, especially among members of minority groups, for whom a conditional sentence is not a sentence. For Roma, a conditional sentence is not a sentence. This is an exception, of course, and this judge had this stupidity to put this in his judgment, but we know how many judges, in fact, have this in mind without writing this into their judgments and without allowing later for the European Court of Human Rights to find discrimination. Well, that was all I wanted to say. Thank you very much, and I'm looking forward to your questions.
Thank you, Krasimir, and I hope we'll save a few minutes at the end to come back to the question of proving discrimination, and especially in the courts, and developing arguments for that. So now we're going to discuss the discrimination against women, and our presenter is from Afghanistan, Ms. Samira Ishkazi. She's the head of the ILAC Afghanistan Women's and Children's Rights Unit. We're going to have a consecutive, as you would like, consecutive interpretation. Yeah, so please, Samira.
Hello to everyone. This is Samira Ishkazi, as a woman unit head in ILAC organization. I want to talk about the discrimination of women in legal aid system. البته که ما میخوایم دو قضیه را به صورت عملی رویش صحبت بکنم که کدام موارد تبعیض‌آمیز علیه زنان وجود داره و ضمناً کدام چالش ها است که ILP چگونه در قبال از او فعالیت را انجام داده.
I'd like to talk about 2 practical cases at which I'd like to bring to your notice what have been the discriminatory approaches and what challenges have existed, and against such challenges and discriminatory approaches, what has been the stand of ILFA.
دوستا قضیه را داشتیم که خانم مورد لاتکوب قرار میگیره، البته از طرف یک شخص زورمن که اونا خانم قسم ونمود میسازه که شخص پلیس می باشه و در همسایگی از اینا قرار می داشته باشند. زمان که خانم میخواه می دیوار منزلش ایمار بکنه، این شخص نمیگذاره و این احساس میکنه که گویا این خانم میخواه که منزلش غصب بکنه، زمینش غصب بکنه، بنان بالایش ادعا میکنه و این خانم را با وصف از که شدیدا لاتکوب میکنه، با وصف از که خانم متضرر میباشه، این خانم در نظارتخانه به سر میبره و بعدا زمانی که وکیل مدافع ایلفی به این دسترسی پیدا میکنه چندین روز با وصف از که از این قضیه گذشته میباشه، وکیل مدافع ایلفی میره امرایشان قرارداد میکنه و میبینه که خانم در حالت بسیار بد و وخیم قرار داره و ما زیاد علاقمند به این بودم که ما مو عکس ها را با خود داشتم، به شما نشر میکردم میدیدین که در چی وضعیت بود، ولی چون مو مسئولیت حفظ اسرار به گونه وکیل مدافع داره بنابراین نخواستم که مو عکس ها را منتشر بسازم.
As I mentioned, I'd like to be bringing to you practical cases. First is of a woman who has been brutally beaten by her neighbor. The case is that her neighbor is a police officer, and this lady, when she wants to build a wall inside her home, the man claims against her to be usurping her land and starts beating this woman. Now, this woman happens to be the victim of brutal torture, but at the same time, instead for her being heard, she is taken to the detention center. Finally, after the ILFA defense lawyers found access to her and were able to reach to her. I wanted to bring to you the pictures, the photos of this lady, but being a defense lawyer and respecting the confidentiality of our clients, I could not dare bring those photos to you, but I could tell you that she was really in bad shape.
خب زمانی که وکیل مدافع ایلفی با ایشان قرارداد میکنه، در قدم نخست متوجه میشه که خانم یعنی شدیداً ضربه دیده و تمام اعضای بدنش کبود و زخم برداشته بود. بنابراین وکیل مدافع را وقت پرسان میکنه که آیا سارنوال شما را راجع ساخته؟ به تبدیل خانم میگه که یعنی سارنوال از پیش ما اظهارات ابتدایی ما گرفت ولی کدام عکسی از ما بر نداشت و یکی مرا به ریاست خدمات تبدیلی معرفی نکرد. بنابراین وکیل مدافع ایلفی میره از او عکس برداری میکنه و سارنوال را وادار به این میسازه که سارنوال این موضوع را یعنی شدیداً بررسی بکنه و این خانم را که در حقیقت متضرر قضیه است دوسیهش حفظ بکنه و ضمن خانم را به ضمانت رها بکنه و به خاطر درمان و علاج به مراجع صحی و طبی راجع بسازه.
Our ILFA defense lawyer contact this survivor, ask her, who's very brutally been beaten, as I said, if the prosecutor has taken her photos and have sent her for the forensic check to the forensic medicine. She responds that she has not been referred to the forensic medicine department. Our ILFA defense lawyer works with the prosecutor, forces the prosecutor to make sure that this woman is sent for the medical treatment. Because as I said, she is a survivor, she is not a violator of the right.
خب دقیقاً خوشبختانه که دوسیه حفظ شد در قبال زن و همچنان این دوسیه راجع شد به سارنوال من خشونت و همچنان این شخص دستگیر شد که خوشبختانه امو فعالیت های وکیل مدافع را نشان میده که خانم به این دسترسی داشت و دقیقاً در صورت که همچون مورد را یعنی یک وکیل مدافع و ناس ببینه بهتر قابل درک برشان بود و دقیقاً به مو موضوعات رسیدگی کرد. ولی اگر من فکر میکنم وکیل مدافع ذکور می بود و خانم نمیتونست دقیقاً موارد نشان بده و یا بدن خود به اونا نشان بده که چقدر آسیب دیده.
Fortunately for this case, the case was closed. The woman was sent for the medical treatment. The person who done all this violence was sent to the Violence Against Women Prosecution Unit and was arrested. Why this happened? Because we have a women unit at ILFA and she was a woman defense lawyer who was able to reach this survivor. It will have been much difficult had the defense lawyer been a man because she will have not been able to show her parts of the body that had the signs of the torture to a man. So it's always very comfortable if there are female defense lawyers reaching out to the female survivors and victims.
دوستان ما قضایی دقیقا زیادتر شدیدتر داریم ولی ما به گونه مثال تو قضیه را من میسازم به شما و قضیه دیگه را که داشتیم البته قضیه قتل بود که خانم متهم به قتل شوهرش بود در حالی که هیچ گونه مواردی وجود نداشت که گویا الزامیت از خانم را ثابت بسازه. زمانی که وکیل مدافع ایلفی با ایشان قرارداد میکنه و میبینه که در دوسیه یعنی همون موارد لازمی را که الزامیت از خانم را مشخص بسازه وجود نداشت، وکیل مدافع ایلفی تلاش میکنه تا اینکه این خانم را به ضمانت رها بکنه. ولی یک چالش عمده که در جامعه ما وجود داره با وصف از اینکه قوانین ما است در مورد صراحت داره که یعنی در هر نوع قضیه میتونن اینا به ضمانت رها شوند، ولی با وصف اینکه قانون حمایت کرده و چنین اجرات صورت نمیگیره ولی با آن هم وکیل مدافع ایلفی دادخواهی میکنه تا اینکه این خانم به ضمانت رها شود.
There are many cases, respect friends, unfortunately, of such violence and ill treatment. I wanted to bring them all, but could bring you just some as example. I'll just bring one more. That is of a woman who is alleged for the crime of her husband's murder. There were no evidence whatsoever at all. There were no grounds to prove that this woman had been involved in the murder of her husband. Again, the ILFA defense lawyer contact this lady, do the advocacy, and want for this lady to be released because there had not been any grounds. We have laws in Afghanistan. The laws are very clear that persons can be released on bail, but then in practice at times it's quite different. But the thing with the ILFA defense lawyers has been on this case that there was a strong advocacy done for this woman.
خانم خوشبختانه براءت میگیره و زمانی که براءت میگیره باز هم ما به چالش مواجه بودیم، یعنی قوانین ما را حمایت کرده شخص الا قطعیت حکم یعنی بری ذمه می باشه، ولی با وصف از او هم قانونی عمل صورت نمیگیره و شخص با وصف از که براءت هم حاصل میکنه ماها در حبس به سر میبره و خانم همچنان به همچون یک مشکل مواجه بود زمانی که براءت حاصل میکنه و بالاخره به خاطر تایید حکمشان ایجاب میکرد که باید به دوسیه بره به محکمه دو و بالاخره اونا تایید بکنن و زمانی که قطعیت حاصل کرد بالاخره این خانم رها شود، ولی با وصف از او هم وکیل مدافع ایلفی تلاش کرد تا اینکه خانم را بعد از براءت نیز رها بکنه.
Well, for this case, as I said, there weren't enough grounds against this woman. She was acquitted by the court, but that's not the end of the story. Unfortunately, in laws, it is said that it is the presumption of innocence that we need to consider. But with all this, the woman still had to be in the prison until we, the ILFA defense lawyer, did the advocacy for her to be able to bring her out of the prison. But she already spent some time in the prison, yet being innocent and acquitted by the court.
مورد دیگه که واقعا اوناس در قبال از او به چالش مواجه هستند عدم موجودیت وکیل مدافع اوناس است که در تمام قرا و قصبات ما نمیتونیم یا نداریم وکیل مدافع اوناس را نداریم و این هم دلیلش عدم امنیت خوب است و ضمن خانم‌های جرأت را نمیکنن که بیشتر برن در ولایات وکالت دفاع را پیش ببرن و ضمن ما عملا یعنی چنین مواردی را داشتیم که خود وکیل مدافع اوناس در مرکز مورد تهدید آزار اذیت قرار گرفتن و شخصا به ما چندین مورد تهدید مواجه شده. بنابراین وکیل مدافع با وصف از اینکه مراجع عدلی و قضایی چندان امرایشان همکاری هم نمیکنن و ضمن اونا را به نحو در برابرشان به احترامی صورت میگیره و همچنان مرجع خوب وجود نداره که یعنی اینا بتانن دوسیهشان مطالعه بکنن و یکی که در یک محل مسکون و یا آرام اونا قرار داشته باشند.
As I mentioned at the beginning, I'll also refer to some of the challenges. One among such challenges is the insufficient number of female defense lawyers in Afghanistan, and that is because of the insecurity across Afghanistan, which is one main factor why women will not dare take on the job of the defense lawyer to serve in the different rural part of Afghanistan that unfortunately are affected by insecurity. That being one, and then the other problems are there are unfortunately unfortunately still cases of harassment against women. I personally have been intimidated at times at my job. There are at times sort of disrespect towards female defense lawyers and not sufficient amount of time given to your cases by the relevant authorities to properly read them.
مورد دیگه دوستا در ارتباط ای که ما شما میفهمیم که آزادی حق طبیعی انسان ها از و قوانین نیز حمایت کرده، ولی زمانی که در راه عام دو شخص با هم گشت و گذار میکنه، مثلا پسر و دختر، از جانب پلیس اینا مورد آزار اذیت قرار میگیرن و اینا استاده میشن و برشان گفته میشه که گویا چی قرابت بین هم دارین، بنان به نحو اینا آزار دیده میشه و بالاخره اینا نمی خانم به خاطر تثبیت معاینات هایمن راجع میشه بر ریاست خدمات تبادلی، در حالی که اگر چنین خانم یعنی باکره نباشه اینا را دفعتاً الزامیت بر این بالایشان ثابت میسازن که گویا این خانم مرتکب کدام عمل زنا شده باشه.
Another thing adding to the problems in Afghanistan is we know that freedom is a natural right given to every human being. But in Afghanistan, if a man and a woman are walking around, the police will suspect you for being into some religion. And they will send you to the forensic medicine for the check of virginity. Okay, if the woman happens to be not virgin, that would mean that this woman has committed adultery, for which crime you will be then probably prosecuted.
خوشبختانه در این مورد هم ما یک سلسله فعالیت هایی را داشتیم که ما توانستیم زیادتر اصلاحات را در قوانین خود جاگزین بسازیم که در کد جزای جدید این فعالیت را ما انجام دادیم که یک اصلاحات جدید را به وجود بیاریم که حداقل ما بتانیم تمام مراجع را یعنی محدودیت را وضع بکنیم بالایشان که هر مرجع یعنی پلیس و سالنوال به صورت یعنی خودمختار نتانند که خانم‌ها را روان بکنن و باعث آزار اذیتشان شود به خاطر تثبیت هایمن.
But fortunately, we have been working on the reform. One of those is our penal code that we recently have approved in Afghanistan, at which now proper reforms have been brought. Certain restrictions have been set on police and prosecutors for them not to be so just easily able to send the women for the hymen or virginity checks.
خب مسائل زیاد از دوستا از اینکه وقت تان نمیگیرم و موقع هم کم است، ما فقط فشرده در ارتباط فعالیت های آینده ما صحبت میکنم که دقیقاً ما بیشتر تلاش به این داریم که دادخواهی های ما را بیشتر بسازیم و نگذاریم که خانم‌ها در برابر همچون چالش ها قربانی شوند و زیادتر میخواهیم که آگاهی در قبال می خانم هایی که بی‌سواد هستند برشان ارائه شود و ضمن در ارتباط ارتقای ظرفیت سانوال صاحبا و وکلا زیادتر کوشش میکنیم که به اثر می دادخواهی های ما و ضمن به اثر ورکشاپ هایی که دایر میکنیم، میزهای گردی که داریم اونا را زیادتر وادار به این بسازیم تا قانونمند شوند. تشکر از توجه همه.
There are so many issues, but because of the constraints of time, I wouldn't be taken about all. I'll just quickly talk about what ILFA does in Afghanistan. We do advocacy, as I reflected in my short speech, and the other thing is we want to do awareness raising so that the women know about their rights and do not happen to be the victims of the crime. We also work on the capacity building. We do this for the defense lawyers as well as for the prosecutors, and in this regard we conduct workshops, roundtable discussions so that we have raised the awareness and helped the capacity build. Thank you so much for your attention.
Thank you, Samira, so much for your incredible work and how case by case you're really making law work for people. Thank you. Our final presenter at this panel is Vladislav Vlasiuk, who is the General Director of the Directorate of Human Rights of Access to Justice and Legal Empowerment section of the Ministry of Justice of Ukraine. Vladislav is going to talk about the experience in providing legal aid to victims of domestic violence in the context of the National Human Rights Strategy. Vladislav?
Good morning, everyone. So in Ukraine, we've got a great system of free legal aid provision that was previously told by our colleagues Ibn Sivan Smechela and Alexei Banyuk. So now I'm just gonna elaborate a little bit more on some things, what we do in Ukraine in very small or narrow cases of domestic violence. The story is that traditionally in Ukraine we've got a very strong society, especially after the last revolution and especially because of the war with Russia. So we've got the activists who on voluntary basis do a lot of work to support some social initiatives. And that was the very beginning of our new project, which is yet quite small, but it is expanding. The project is called as Family Advisors, and it basically means that we work together with the activists from the society in protecting the victims of domestic violence and in ensuring the protection of the rights of the women, of the children, and sometimes of the men. Some people just come to us with an idea, and we strongly supported it within the Ministry of Justice, that the idea is to make a collaboration of those activists and our services. As you know, domestic violence crimes, it is quite latent ones. You never know why and how many are the cases of domestic violence. And of course, a lot of victims, a lot of real victims are just afraid of coming to state services and ask for the help and ask for legal advice. There are many reasons for that. The reasons may be different for different countries. Here in Ukraine, we probably have a lack of luck, a lack of trust in some of state services. And also, the very nature of domestic violence is meaning that the people just wanting to keep it silent for different reasons, for social reasons, etc. Of course, there is also a number which shows that not all the people are aware of the state services to provide free legal aid. Some of those people who do know about the free legal aid center for some reason do not trust that that free legal aid will help them. We also have a lot of new legislations passed in last couple of years aimed at protection of rights of children, aimed at protection of rights of women. But of course, and this is okay for every country, that not all the people know about that legislation. So this is another issue why they do not come and ask for the protection, why they do not come and ask for legal aid. And of course, well, basically the numbers are that only 10% of the victims of domestic violence are really approaching the free legal aid system and ask for the help. One of the major updates in the legislation, it was the package so-called No Child Left Behind, which basically meant the adding of many additional legal tools to ensure that the alimonies are being get back from to the children in the interest of the children. And that in turn meant the additional workload for the state law enforcement system, and this is within the system of Ministry of Justice. So basically, we adopted the laws. We're doing a lot of job to raise the legal awareness about those changes in the legislations, but of course there are still many cases which require additional free legal aid or just legal aid or legal consultation, etc. Again, in Ukraine, we've got a very strong system of free legal aid. We also have a very strong network of legal aid providers, basically the NGOs which work in different areas and help to the people. And again, we just wanted to make sure that this all together is being run smoothly and that everybody knows what everyone does. And so again, about the initiative, the family advisors. So those are the women who basically went through the horrors of being victims of domestic violence. The number is just about 10 or 15 right now, not many of them, but they came to us. Nice story that they already had a very big Facebook page, Facebook public. They've been working with another people for half of the year, and the very basic difference is that they're just the same. They're just the same women who were previously beaten up or something, or who previously made it all the legal way to obtain the alimonies, and they know how the mechanisms work, how the state service work. So they have the trust. They have it earned, the trust from other women. So now we work together with those women, with those family advisors. We just made it sure that they have all the answers required from our state services, especially our court enforcement system, court decisions enforcement system. So basically it is now in several major cities, in our offices of free legal aid, and the story is as follows. The women, our family advisors, come and sit at the free legal aid offices for a couple of hours every week. So then the women or other victims of domestic violence can come to the office and ask the question to our family advisors. They have the trust, they know how the system works. We make sure that the representatives of another state services, especially the social services, the police, that they are present during these hours, and they can also answer the questions. So that meant that we gained the public trust in those very delicate cases, that we managed to coordinate the different services from the state, both within the Ministry of Justice and within other ministries. And this is just the beginning of this project. This is just pilot, but again, it already showed great results. We managed to help to the women, to the victims of domestic violence who never ever came to ask for their legal aid to the state. And we really think that this is a major success so far. And we're just piloting and we are expanding it to other cities. We are having more activists, we are having more family advisors coming to us and with readiness to help. And from our side, as Ministry of Justice, we are ready to support those actions. So far we've built already a small network of those family advisors. They're also very active on Facebook. And again, we are a very Facebooked country. So, I mean that this is yet small pilot, but with very tangible results. And we are looking forward to have more results, and we are looking forward to have more victims of domestic violence protected in this manner. Thank you for your attention.
Thank you, Vladislav. Ukraine is a real leader on a number of fronts, including legal empowerment generally, and it's great to see these very, very specific efforts that government is putting in place to really respond to the needs of victims of domestic violence. So we started late, so we have 10 minutes for questions, comments. So I'll get up to see the hands. So David, anyone else? Yeah, please. So if you can just introduce yourselves and 3, 4. So why don't we start with David, please.
Okay, can you hear me? David McQuaid Mason from South Africa. Something I didn't hear raised here, but I know it happens in our country and I'm sure in many others, when perpetrators of violence against women and children actually go to court. In our country there's a very low conviction rate, and I'm not sure, largely because of the way that the police handle it or the prosecutors. So what we do is we've got a training manual where we put together police officers, prosecutors, district medical officers, NGOs, and nurses, people out in the field, to get them to work together so the women and kids get their day in court, but we also bring in the legal aid lawyers, so you actually get a fair trial, but you make sure the chain of evidence is not lost. You also build relationships. People in the different towns where you do them know this is the police officer who specializes in these offenses, this is the prosecutor, and so on. We have that resource, Street Law South Africa. Is anybody interested? It's a 3-day workshop. Medical law and ethics, psychological support, and collection of forensic evidence by doctors.
Thank you, David. So please.
صباح الخير. أنوار من تونس. I will speak in Arabic. هناك عديد الدول لا تعترف بوجود التمييز، لذلك يكون التمييز أكثر عمق، وأول الاعتراف بالتمييز هو اتخاذ قوانين تجرم التمييز. وهنا نأخذ مثال تونس مثلا، يوم 23 أكتوبر 2018 اتخذت قانون يتعلق بالقضاء على كافة أشكال التمييز العنصري، ومجرد الاعتراف يفتح المجال للمساعدة القانونية، وبالتالي هو باب يعني مهم. وطالما الدول لا تعترف بوجود التمييز فهناك أيضا هذه العراقيل. المسألة الثانية تتعلق بالعنف القائم على أساس الجنس أو العنف القائم على أساس النوع الاجتماعي. تونس أيضا اتخذت قانون في أوت 2017 يقضي على كافة أشكال التمييز ضد المرأة، ولا فقط هنا نلاحظ أننا دائما يعني نحصر التمييز ضد المرأة فيما يتعلق بالعنف الأسري. في تونس تم تجريم كل أشكال العنف الاقتصادي، السياسي، الأسري، الجنسي، وبالتالي هناك مقاربة شاملة لهذا القانون، ومجرد الاعتراف به هو أيضا فتح مجال للمساعدة القانونية، والمساعدة القانونية مفتوحة لكل النساء ضحايا العنف بصرف النظر عن الموارد الاقتصادية. أي امرأة ضحية عنف من حقها الحصول على مساعدة قانونية، وهذا أيضا من بين الممارسات الجيدة التي يمكن أخذها بعين الاعتبار للقضاء على كافة أشكال التمييز. كذلك الأخت في أفغانستان تم الحديث عن أن لا وجود للنساء. في تونس الوحدة المختصة بشكاية قضايا العنف بالضرورة يجب أن تكون فيها امرأة، وبالتالي هذا يرفع الحرج على الامرأة في التقاضي والوصول إلى القضاء، وهي أيضا ممارسة جيدة. وكذلك التمييز العنصري لا فقط في الضحايا بل أيضا في الوصول إلى مراكز القرار. إذا لم يكن في القضاة نساء، إذا لم يكن في القضاة معناتها من سود البشرة وغيره، فإن ذلك أيضا يعتبر تمييز. عندي سؤال بالنسبة للإحصائيات التي تم عرضها في أحد التجارب، وهي إحصائيات قائمة على معايير التمييز. هناك من هو من روما، هناك من هو أصل مسلم وغيره. ألا يكون هذا أيضا أساس للتمييز إذا ما اعتبرنا ذلك ولم نعد إلى الأسباب وراء وجود هذه الجرائم أو الولوج إلى معناتها الصعوبة في الولوج إلى القضاء؟ شكرا.
So I understood what you said, but on the question, it was on Roma. Was your question about Roma? Of Bulgarian representation, Roma women.
The crime, this crime, I'm affected to Muslim, those for Roma, and we are based on criteria of discrimination.
Yes.
So they are citizens in that yes. country. Why we make this segregation between criminal?
I see. Krasimir, did you get the question? Yeah. Yes. Okay. Thank you. So there were two hands there, one and somewhere here. Yes. Please, from Armenia. Yes.
Yes. I'm Asan Boone, chairperson of Legal Aid Committee from Pakistan. I'm heading the Legal Aid Committee of my country. I have only 2-3 suggestions. I have heard the speeches of honorable speakers from different jurisdictions all over the world, and they have highlighted the very important issues, and particularly today, with perspective to Ms. Samira from Afghanistan, but we have seen that there are certain violations. Although all the countries have very good codified laws, there are criminal procedure code for the purpose of fair trial, there are certain articles in the Constitution with regard to the fundamental rights. Similarly, there are laws with regard to juvenile justice system, particularly in my country, civil laws, civil procedure code, all well-worded codified laws. But the problem is with regard to the violations, and particularly we must urge in our resolution that all the member states of UNO, they should be given this resolution that the legal aid should be state-funded institution, and all the member states must fund with regard to the legal aid authorities, and they should establish certain centers. Secondly, all the member states also conveyed about the highlighted violations in different countries. So they should know what is going on and how the people are being prosecuted, what discrimination is being conducted, how their dignity is being jeopardized, how they are not treated in accordance with law. These are all issues which have been highlighted here in this conference. So these should be made part of the resolution and should be conveyed to the UNO through concerned states. Thank you very much.
Thank you. Thank you very much. From Armenia, and just we'll take one more only. And okay, just very quick. So please take a few seconds to ask question or make comment. Yeah.
Okay. Thank you very much. I'm Marina from Armenia, UNDP country office. First of all, just very quickly, I wanted to say that I very much agree, and thanks, Rick, for this presentation. Speaking about persons, I mean we often so much speak about numbers and legal frameworks that we often forget that behind all those numbers there are people and there are lives and there are families. So each case can be a broken life, a broken family, especially the story that we heard yesterday from Tony. This is really changing a lot, and I would really appreciate and I would really encourage that the legal aid providers really think about people and not just the cases and numbers and statistics. And my question actually goes to Ukraine. I wanted to ask, it was not quite clear to me, these women are consulting, women are subject to domestic violence before the case is brought to the police or after the case is brought to the police and they support them to get free legal aid? Thank you.
Okay, thank you. And here it was, please, one, and we need to close here, so please, yeah.
I am Juyu Ang, ILAC Myanmar lawyer. I have two questions to Mr. Rick Jones. Regarding with Ali and Board and case, I want to give an example. The defense lawyer trying for client's right of defense. The defense lawyer submit power of attorney, permission to represent, and trying to represent in the remand hearing state, but the judge didn't even accept the power of attorney and didn't let the defense lawyer to argue in remand hearing. And there was no record about this in the court case diary. Next examiners, the client withdraw the power of attorney because the police told him that there will be more than one charge if the client have a lawyer. If the client is not represented by lawyer, there will be only one charge against him. Then the client decides to withdraw the power of attorney. How a defense lawyer should deal with in these situations? Thank you so much.
Okay, and the final.
Thank you very much for very interesting speeches. Just very quick question. Even though the panel was directly mainly or addressing the criminal justice and discrimination in criminal justice. When we're talking about discrimination, criminal justice is of course an issue, but then we also should look at the other rights and discrimination in general. So it should be also very interesting to hear very briefly on the role of the legal aid lawyer in civil and administrative proceedings as well in cases of discrimination.
Okay, thank you. So I'm asking panelists to take really 1 minute each for quick responses. Maybe we start with Andre. Can you respond on discrimination in civil matters, how you respond to those in non-criminal cases? Yeah.
In Brazil, the public defense in charge of defend people in criminal cases and in civil cases also. So for example, in criminal case, when we have people killed or injured or people tortured, we can file lawsuits against the state in order to compensate those people for the problems they suffered. Also in matters of domestic violence, we can provide many other support for women. It isn't interesting because in Brazil, the Public Defense Office must defend not only the victims, but also the offender. So it's ambiguous, but to protect the victims of domestic violence, we can also provide other legal support to find a new house, to be protected, hide from the offender. And so there are many civil measures that we can manage and deal in order to protect the victims.
With respect to the civil, so yeah, I think that in many cases, the civil issues are more important than the criminal issues, and I think that the racism is just as deep and just as profound in the civil cases as they are in the criminal cases. Particularly, we are the largest provider of family defense services in Manhattan. And one of the things that we see constantly is that black families are treated differently than white families. And when it comes to removal of children and putting children in foster care, similar conduct is not treated similarly. And taking your children away is always, I think, to a mother more important than whatever's going to happen to her in criminal court. So the civil racism is just as profound, and the civil issues, whether it's being deported or losing your home or your educational rights or your children to foster care are oftentimes more important than the criminal case, and the racism is there. With respect to the power of attorney, I'm not sure that I fully understood the question, but it sounds to me like the client was coerced into not having a lawyer because the theory was that if you have a lawyer, we're going to charge you with 2 or 3 or 4 charges, but if you don't have a lawyer, it'll just be 1 and we'll go easier on you. I think that the 2 things that I said that apply to that are, one is community education. You have to get in the community. You have to educate people that they have rights, that the Constitution applies to them. They have to know your rights. We do a know your rights training so that people are not intimidated out of getting a lawyer by the police or by the prosecutor, but that they understand what their rights are and they know that they're going to be ultimately better off if they have good, competent, well-trained counsel. So I think that's part of it, is education in your community. The other part is getting involved in cases early. If you can get involved in the case before the police have the opportunity or before the prosecutor has the opportunity to intimidate and to threaten and to harass and to cajole, then I think you have a much better opportunity in representing the client, in making sure that the charges are fair and accurate and apply to whatever the circumstances are, and also that there's a just outcome. So I would say get involved early, and also do the community outreach, do the community education, do the Know Your Rights training for the community, so that people feel empowered and are not intimidated by the police, because it can be a very intimidating thing to be in that circumstance.
Thank you. Irmina, would you like to react to anything? Yeah.
Okay. Let me respond to the question of why are Roma discriminated against in Bulgaria? Well, this is a question that we can ask perhaps about any other country
and about lots of groups. Why are gays and lesbians discriminated against in many countries? Why are women discriminated against? Why are the Jews discriminated against? Why are the Muslims discriminated against? For all these discriminatory practices, there are different reasons, cultural, religious, political reasons related to social status, to class. With regard to Roma in Bulgaria, there is a history of exclusion of this ethnic group, as in many other countries of Europe, marginalization, there's a lot of poverty, and those are all factors that contribute to their severe discrimination. With regard to the second question on discrimination in other areas, our organization dealt with lots of other cases of discrimination related to lots of other minorities. One example would be, for example, cases of forced evictions of Roma. We have had cases in the European Court of Human Rights. You can take a look, for example, of Yordanova and others v. Bulgaria. A very interesting discrimination case of forced eviction of Roma from their only house. Then, with regard to discrimination of Muslims, we have a very interesting pending case in the European Court of Human Rights. You can also take a look. It is communicated. It's called Yordanovi v. Bulgaria. This is an attempt of a group of Muslims to establish a Muslim party, Muslim Democratic Union. They have picked the statute of a Christian Democratic Union, wrote Muslim where there was Christian, and they were prosecuted and convicted, because in our criminal code we have a conviction, criminal liability for establishing political party along religious lines. Christian political parties are allowed, Muslim political parties are not, and we are now expecting the judgment of the European Court of Human Rights.
Thank you. Samira, please, 1 minute, everyone, please.
دقیقاً قسم ما شما میفهمیم در تمام جوامع قوانین حاکم است و در جامعه ما در ارتباط ای که گویا اگر خشونت در قبال زن صورت بگیره قانون من خشونت علیه زن حاکم است. دقیقاً در صورتی که اگر خشونت در قبال زن صورت میگیره حتی همین قانون تذکر رفته که نمیتونه از اساس امتیازات برخوردار شود، از امتیاز عفو تخفیف برخوردار شود. بنابراین قوانین حاکم است، ولی که احساس موارد ایجاب میکنه که اینا مراجع عدلی و قضایی بیشتر آگاهی پیدا بکنن، ولی یک ممکن وقت بیشتر نیاز داشته باشه و ای که ممکن مراجع عدلی و قضایی در ارتباط اگر مشکل مواجه میشه و یا چون چالش را برخورد میکنن دقیقاً که مجازات را در قبال دارن.
I just want to reiterate on this one point that in Afghanistan, despite all these challenges, there has been significant progress. When we talk about significant progress, as we are talking about the violence against women, and we are talking about women survivors, we have a law approved in Afghanistan by the name of Elimination of Violence Against Women. That has a lot of punitive provisions in the law. And the thing about the punitive measures in the elimination of violence against women in law is that the suspect prosecuted under the elimination of violence against women law cannot enjoy any privileges, because at times during the Eid holidays some prisoners might be pardoned by the president of Afghanistan, like after little time of your imprisonment is left. But if you are convicted under elimination of violence against women law, you will not enjoy any such privileges. Okay, we still have a long way ahead, but there has been at the same time certain progress which is significant.
Thank you. And Vladislav?
Well, unfortunately, we do have some cases of racial discrimination or something, but well, generally this is quite low, and well, generally we have great understanding between the different ministries on how to battle those cases. So I mean that I wouldn't say that this is a really problem on a big scale in Ukraine.
So thank you very much. I would like to thank this panel. Thank you for the participation. We will now take a 20-minute break so that we can catch up with time. So please come back at 11:15 a.m. So thank you, and please join me to thank the panelists again for their presentations.